This is Bloomberg Law with June Grasso from Bloomberg Radio.
This is a prepaid call from
Syed.
His case captured the attention of millions on the hit podcast Serial, which raised doubts about his conviction for the murder of his former high school girlfriend. There have been so many extraordinary twists and turns in Adnan Syed's 24-year legal saga. It seemed like the case was over in 2022 when a judge vacated Syed's murder conviction after Baltimore State Attorney Marilyn Mosby found errors in the prosecution of the case against him in 2000.
The Attorney General's office failing to disclose relevant information on the alternative suspects, one of whom threatened to kill and had motive to kill this victim, both of whom had a pattern of violence against women and sexual assault, the improper clearance of the suspects by investigators based on faulty polygraph tests, the faulty cell site information that is used today that was used then that wouldn't be used today.
Syed was released after serving 23 years in prison, but now the 42-year-old is facing prison once again. The Maryland Supreme Court has ordered a redo of the hearing that freed him 2 years ago, ruling that the rights of the victim's family were violated because they weren't given enough notice of the time of that hearing. Syed has maintained his innocence throughout.
We definitely understand that Hayes' family has suffered so much, and they continue to suffer. And it's just that we suffer too.
The closely divided ruling means that Syed's murder conviction is reinstated for the foreseeable future, although he remains free pending a new hearing. Joining me is trial attorney David Ring of Taylor & Ring. David, the former Baltimore State's attorney Marilyn Mosby has said that this decision sets a dangerous precedent over a prosecutor's ability to reverse an injustice. If prosecutors decide they've wrongly convicted someone, shouldn't it be their decision to drop the charges with a rubber stamp by a court? Why should the Supreme Court here interfere?
The court has a say in that because the court's the ultimate gatekeeper. You know, we have to have checks and balances. Look, most of the time, if the prosecution comes in and says, hey, you know, this guy's wrongfully convicted, the vast majority of the time the court's going to agree with them and drop the charges. But the court still has to sign off on it. There still has to be some sort of hearing, and it's just a way to have checks and balances to make sure that everyone's playing fairly in the system.
The only issue is that the victim's brother, who spoke at the hearing by Zoom, argues that he didn't get enough notice of the proceeding. He was told on Friday about the hearing that would take place on Monday. That's the only issue here, right?
That was the issue, but here's the bigger picture on that issue, because the way it's kind of framed sometimes in the media, it's like, well, what's the big deal? He appeared by Zoom. But that hearing was a monumental hearing. That was a hearing where the prosecution basically came into court and said, hey, court, we want to drop these charges. We want to have this conviction overturned. And what Maryland's highest court has said in response to that was, if you're going to have a hearing like that, the victim or the victim's representative absolutely has a right not only to be there in person, but to be heard. And that's a big part of this ruling, is that, you know, the victim's brother, Mr. Lee, he was in California. He was given notice on a Friday to be there Monday. He had an attorney who was representing him. They said, hey, give us another week. We want to be there in person and we want to be heard. And they weren't given that opportunity. And the key to this decision is, if he had been given time to come to Baltimore to appear in court with his lawyer, the lawyer has a right to argue basically in the shoes of the victim and say, why is this conviction being dropped? There's plenty of evidence here. This guy did it. There's no new evidence to drop it. And they basically have a right to challenge the prosecution's decision to drop the case. That's where this decision is so important.
In Maryland law, there's no set time for notice to be given to the victim. So how did the court here decide that the victim's brother wasn't given enough notice?
It's a reasonableness standard. And so basically, in a very close decision, 4-3, the Supreme Court said it's not reasonable to tell the victim's representative on a Friday that you're having a hearing on a Monday and say, oh, gee, but you can appear by Zoom. That's not reasonable. They have a right to be there in person. So what's reasonable? Okay, set it a week out, 2 weeks out, but setting it on the next business day, unreasonable. It denied the victim's representative of his right to be in court and to be heard. That's the key.
In the dissenting opinion, and as you noted, it was 5-4, so closely divided, Justice Michelle Houghton argued the issue was moot because the underlying charges no longer exist. Quote, "This case exists as a procedural zombie. It has been reanimated despite its expiration. The doctrine of mootness was designed to prevent such judicial necromancy." What evocative language there.
I totally disagree with her. I think in this day and age, victims' rights are incredibly important. And too many times the victim or their family, their rights get trampled in the criminal process. And the prosecutor, remember, the prosecutor represents the people. They don't necessarily represent the victim's family or the victim. And so I think what Maryland Supreme Court has said here is, hey, you know what? We're going to respect the victim's rights here. And this victim had his rights trampled upon by this prosecutor who quickly went into court, had completely reversed course on how they felt about Syed's conviction, and suddenly was willing to let this guy go free. And basically the Supreme Court of Maryland said, hey, that's not fair. This victim, her representative, has an absolute right to be there and to challenge that decision by the prosecutor. Look, I think if you want to kind of read between the lines here, sometimes we have to read between the lines of how these decisions get played out in the highest courts. I think that the Supreme Court is basically saying, we don't think Syed should be free. We think there should be a new trial.
The rights of the victim are one thing, but you know that our justice system is far from perfect, and there are a lot of wrongful convictions. So how do you weigh, the rights of the victim versus the rights of a defendant that the prosecution says now was wrongfully convicted?
Well, here's where this dynamic kicks in. Again, it's all about the opportunity to be heard and to have a fair playing field. And so when the prosecution came in 2022 and said, we have new evidence which we think exonerates Syed, well, they did that behind closed doors. They didn't do that in open court. It's come out what the evidence was, but I'll tell you, if you have fresh eyes on that so-called new evidence, I'm not sure how new or exculpatory it really is. I mean, there's no DNA on her shoes. To me, that's like a so what? She was strangled to death. Why would there be his DNA on her shoes? I get it. There's two sides to this case. There are people who absolutely believe he got railroaded and didn't do it, and there's people who believe that he absolutely did it. And so the Supreme Court is saying, you know what? Not so fast here. Not so fast, prosecution. There's got to be a hearing on this. We want to shine a spotlight on what your new evidence is and what your reasons are for suddenly reversing a conviction and letting a guy go free, and we're not going to let you do it behind closed doors.
Now, there's another twist in the case because the Baltimore State's attorney, Marilyn Mosby, who had moved to throw out the conviction, she's no longer the Baltimore State attorney. And now there's a new Baltimore State attorney, and his office said it needed time to review the Supreme Court's lengthy opinion and to determine whether his office has a conflict of interest in the case. What kind of conflict of interest are they referring to?
So you have a new prosecutor, Ivan Bates, and in his campaign to become the prosecutor, he seemed to be a proponent that the conviction should be dropped. So look, he's in a political pickle right now, because it's a tough decision. Do you drop this conviction for murder, or do you go ahead and reverse course yet again and have a new trial? So he might take the easy way out. He might punt it to another independent agency and let them make the decision. He may look back at it and say, hey, there's just too much water under the bridge here for this Baltimore prosecution office, and we've lost credibility on this case. Let's let another state agency come in and make that decision for us.
This decision was a close one. Syed has been out of prison for 2 years. The former state's attorney is on record talking about the many problems with the original prosecution. And it's been nearly a quarter century since the murder. Do you think any prosecutor, any state agency would say, we're going to refile the charges and have a new trial?
I don't think anyone's expecting that decision to be made, because that's a tough decision to say, you know what, we're going to have another trial, we're going to go through this all over again, and that's going to be more years and more appeals and all that. And, we're going to take this guy who's now out there and free, and we're going to put him back in prison. That's the toughest decision to make. And you're right. The easy decision is we're just going to let things stand where they are. We're not going to pursue this any further. It's been going on too long already. He was convicted in the year 2000. This case has been going on for a long time. But it's not over yet because we still have to have this new hearing. The Supreme Court said there's going to be another hearing on whether this conviction is going to be dropped. The victim's brother has a right to be heard at that hearing, and then there could be appeals that flow from that.
Although if the victim's family gets its chance to appear and the charges are dropped again, that should end the appeals. Also, we haven't talked about the obstacles to trying a murder case 25 years later.
Very, very difficult, especially given this incredibly high-profile nature of this case and all the interviews and the podcasts and all of the statements made by some of the key witnesses over the years and wildly inconsistent statements. And let's face it, the forensic evidence 25 years ago is far different than what it is today, DNA and cell phone towers and all that. It would make it really, really tough to retry this case 25 years later.
It does seem unlikely. Thanks so much, David. That's David Ring of Taylor & Ring. Coming up next on the Bloomberg Law Show, NFL Sunday Ticket subscribers are appealing the tossing of their multi-billion-dollar verdict against the NFL. And Yelp is the first rival to sue Google. I'm June Grasso, and you're listening to Bloomberg.
With NFL Sunday Ticket on YouTube, you can watch your favorite teams out of market Sunday games. So no matter where you live, it'll feel a little more like home. At least on Sundays. NFL Sunday Ticket, only on YouTube and YouTube TV.
The legal battle over the pricing of the NFL Sunday Ticket broadcast package has been going on for 10 years. And it's not game over yet. The NFL lost at trial in June when a jury awarded the Sunday Ticket subscribers $4.7 billion after finding the NFL violated antitrust laws in distributing out-of-market Sunday afternoon games on a premium subscription service. But then in August, the trial judge tossed out that verdict, concluding the jury calculated the damages improperly. So it comes as no surprise in this long-running legal game that the subscribers are appealing the judge's decision. In fact, the case was dismissed once before in 2017 and then reinstated 2 years later by the Ninth Circuit Court of Appeals, the same court where this appeal will be heard. Joining me is antitrust expert Harry First, a professor at NYU Law School. So, Harry, the judge said that there was liability, but the jury miscalculated the damages, so he threw out the jury award. But then he didn't order a new trial.
Right.
That seems odd to me.
Well, yes, that's presumably going to be one of the arguments on appeal as to whether it should have been returned for a new trial on damages. Now, as I read the judge's opinion, the judge said, well, it looks from the number that the jury came up with that they didn't really rely on the experts' evidence. It wasn't clear how they got to these numbers. I'm not quite sure why the plaintiffs should not be allowed to, to come forward with evidence on damages that are not from these flawed, well, what the judge found was flawed damages estimates. So I'm not quite sure whether that's going to be supportable on appeal. The judge did say, you're right, that there was sufficient evidence from which the jury could infer a violation of Section 1 of the Sherman Act. Well, that's a pretty important finding. So I think, this argument is yet to be fought out in the Court of Appeals as to whether that's supportable. And it sort of raises a good question about how we feel about these juries in these complex cases. And it seems to me that the desire of plaintiffs, this includes the federal government, to bring their cases before juries is increasing precisely because jurors do have a sense of, they are consumers, and they have a sense of when things have gone wrong in the marketplace. So I think this will be an interesting one to follow through on appeal and see whether that is supportable and whether plaintiffs should have gotten a new trial.
Do plaintiffs' lawyers and the government want juries because they might give awards that are larger or perhaps based on an emotional response to the evidence, unlike an award a judge might give?
Well, I can't psychoanalyze plaintiffs' lawyers. I think they assume that jurors might be more open to large damages awards than judges who, judges can be pretty skeptical, and judges are often conservative. That's how they got there. And I don't mean conservative in a Republican point of view. I mean just generally, they're conservative. They're not lay people. So, yes, maybe plaintiffs think that jurors are a more hospitable forum. But I think it goes beyond that. I think it goes to the question of jurors being not as attached to technical evidence as to, sort of a broader understanding of how the business operated and what the defendants have done. And they haven't seen it all before. Judges may have seen a lot of this before. So they may come with a more open mind, that may be better and in some sense more democratic.
This is the 10th year of this lawsuit. I mean, they could win the appeal, then there could be another trial, then more appeals. Is this something that could be settled, or after 10 years, are they dug in?
I hadn't really thought about that since they hadn't settled before. I think, lawyers assess risk, and the NFL assesses risk, and the owners assess risk. So is it possible to settle this? Well, there's a liability finding, so maybe that will be possible. But on the other hand, at this point, the worst that can happen for the defendants, I guess, is a new trial. Now, that might just make the cost of settlement more expensive, I guess, or maybe the plaintiffs then would be more willing to settle. So it's a delicate issue. Settlement's possible at any time, even while the jury's out. And, there's more that will go into it, including the defendant's reputation for whether they'll settle or sue.
Let's turn to another antitrust case. And they just keep coming and coming from the government and from private plaintiffs. Yelp is the first tech rival of Google's to sue the search giant to try to capitalize on last month's landmark decision finding that Google is a monopolist. Yelp didn't even wait for the Google case to be finished. Judge Amit Mehta still has to decide on the remedy. Can you tell us a little bit about Yelp's complaint?
Well, I think generally, Yelp has felt that Google has stolen their lunch, the right phrase.
It's a good phrase. I don't know if it's the right phrase.
Right. All the local reviews, Google has incorporated into its own system and then gotten advertising off of it, including reviews. So, to the extent that Yelp has to buy advertising, under Google to get viewers to then click onto Yelp is one problem. And another problem may be the way reviews are done and whether Google has self-preferenced its own search results over Yelp's. Basically, I think they're complaining that Google runs its business in a way that makes it very hard for Yelp to compete because, they control the search engine results page. And in the end, degrade searches by favoring their own results, or at least that may be what they're claiming.
Judge Mehta found that Google had a monopoly in general search. Yelp is talking about the local search advertising market. So how relevant are Mehta's findings to Yelp's case?
Well, he looked at really a different market. First of all, rejected the idea brought by the states that there was some problem with vertical searches, search engines, which Yelp is. So the advertising market that Yelp is alleging is different than the search advertising market that Judge Mehta focused on. So they'll have to slog through that. The idea that there is some degree of degrading of search results, which is shown by preferencing Google search results over others, that may help. But again, I think this is all going to have to be sort of fought out anew by Yelp at this point in the litigation because they don't get any technical benefit from whatever findings Judge Mehta made. And Judge Mehta decided on a somewhat different market than I think Yelp is alleging.
The Yelp complaint was filed in the Northern District of California. Judge Mehta is in the D.C. Circuit. His ruling doesn't even have any precedential power in another circuit.
Well, it doesn't have any precedential value now in a technical sense at all because it's not final and it hasn't been appealed. So what Judge Mehta's opinion has is sort of legal momentum. So similar issues have been presented in different courts, and judges will look to see. They're not necessarily bound. Well, they're not bound, but they look to see, what other judges have done. There aren't that many cases like this. So on product market definition, Judge Mehta looked at a case that involved digital advertising in a completely different setting with different parties, and it was a merger case. So I would expect, a judge in the Northern District of California to consider carefully what Judge Mehta did. It's a very thoughtful, very thorough opinion, and, it may be persuasive. But I assume Yelp filed there for other reasons, like thinking they'll have a better shot on damages and maybe a better shot on appeal. So, there are all sorts of complicated reasons for choice of court. But in any event, even filing in D.C., another judge doesn't have to follow what Mehta has decided because it's still not final.
Do you think that now all Google's rivals are going to start filing private antitrust suits against Google, bouncing off that decision?
Yeah, I think that's, as they say, TBD. A more conservative response is to wait until the decision is finalized for a number of reasons. There are legal benefits to a final judgment. That may be far off, given that this will have to go through appeals. So it's not clear how much they'll want to wait. It's also not clear, what sort of private negotiations might occur, not clear what sort of remedy the government might seek and whether that might help any of these competitors. Antitrust litigation is expensive, and private litigation, although there can be a pot of gold at the end because litigants can get treble their damages plus attorney's fees, the end can be, I guess the end of the rainbow is far off. So it requires a good claim and private counsel who are willing to wait or somehow finance this litigation. So I don't know. We do see this one case. Yelp has been a complainant both in the U.S. and in Europe, but a complainant to the government. So it struck me as a little early maybe, but there are always the possibilities of settlement between these parties. So if we go back to the Microsoft litigation itself, a lot of private parties sued, including potential competitors and licensees of Windows. And some of them got quite substantial, settlement from Microsoft. But of course, Microsoft, eventually did lose on appeal, so that helped a lot. So, yes, I would expect more, not just Yelp, but I'm looking to see whether Microsoft will sue, which I think would be just quite amusing from an antitrust point of view, because, they testified that Bing just could never get any traction because of Google's practices. They couldn't get the scale they needed. So in some ways, Bing should have a good suit. The question, would be what's their damages and what sort of relief do they want? So yes, maybe Bing, maybe DuckDuckGo. We can, start listing them. People are suggesting maybe some, advertisers who complain that the price of advertising was raised because they monopolized this general search text advertising market. All of these cases present difficulties even with the win that the government just had on liability. So no laydowns here, but on the other hand, Google does face the possibility of these sorts of lawsuits.
Thanks, Harry. It's always wonderful to have your insights. That's Professor Harry First of NYU Law School. Coming up next, a judge orders Donald Trump to stop playing the song "Hold On, I'm Coming" at his rallies. I'm June Grasso, and you're listening to Bloomberg. Sam and Dave's 1960 soul classic Hold On I'm Coming is instantly recognizable, from the instrumental introduction to the well-known chorus. Perhaps that's why Donald Trump has been playing the song as his exit music at rallies since 2020, playing it unlawfully, according to a copyright lawsuit by the estate of Isaac Hayes, who co-wrote the song with Dave Porter. The lawsuit says that Trump and his campaign never sought permission or consent from Hayes' estate to play the song and haven't gotten a valid public performance license, even though the estate sent Trump a cease and desist letter in 2020. Of course, many artists have objected to Trump's campaign using their songs. In fact, the ABCs of artists, from ABBA and Beyoncé to Jack White and Neil Young. And don't forget Celine Dion, Bruce Springsteen, Rihanna, R.E.M., Guns N' Roses, Foo Fighters, and on and on. But for the first time, there's an actual legal judgment. An Atlanta judge has ordered Trump to stop playing Hold On I'm Coming at his rallies while the Hayes lawsuit plays out in court. Joining me is Heidi Vaccarano, a partner at Fox Rothschild. Let's say a politician wants to play the song of an artist at campaign rallies. What do they have to do legally?
So it is a little bit complicated because of the nature of how the licensing system is in the United States. So if they're just going to play it at a campaign at a public location, like a convention center or rally, then they need to obtain a public performance license from the public performance organizations, which include ASCAP, BMI, CSAC, or GMR. And you need to obtain a license from each one of them because a song could have various writers that are registered to either one of the PROs. So it's not just that you would go to ASCAP and think that you have an entire license for a song, because there may be 4 songwriters and 2 are registered with ASCAP, 1 is registered with BMI, and 1 is registered with CSAC. So they would need to obtain a license from each of these PROs.
Does an artist have the right to say, I don't want Trump to be playing my songs at his rallies because there's an implication that I'm endorsing him?
Yes, they do. It's part of the rights under the copyright law in the U.S., and it's also considered false endorsement. So they do have the right to deny a use, either through their publishing administrator or their record label.
Is it unusual that a case like this actually gets to a trial judge?
I would say so, yes. Normally, a license like this would be a very simple thing to obtain. And if somebody sends a cease and desist letter, then they would definitely discontinue the use. But I feel like this has kind of gone all the way because of just like the nature of the political campaign.
The Isaac Hayes estate claims that it sent a cease and desist letter to Trump in 2020. If they didn't have a license and they didn't get permission from the Hayes estate, is it a pretty easy decision for the judge to say you can't play that?
Yeah, it should be. Like I said, you would have to check if they have the proper public performance licenses from all the songwriters involved. In this case, you can at least see that it's performed by a separate artist, but written by Isaac Hayes, which is owned by the Isaac Hayes estate. So if they did not have the proper licenses, it should be very easy, according to a Copyright Act.
At the hearing, the lawyers for Trump said a couple of things. They said that the Isaac Hayes estate didn't own the copyright, and apparently the Isaac Hayes estate produced documents for the judge. They also said they obtained a license from BMI Music in November 2022.
I believe BMI had also sent a cease and desist letter too, removing the song from its catalog for use. So at this point, a lot of what the public performance organizations are doing is actively going to their members and saying, if you would like to exclude your works from use by political campaigns, then please contact us and send us a notice letter along with a list of your works that you want to have excluded from use in political campaigns.
So is there a possibility they got a license from BMI at any point?
Whether they obtained a license from BMI, and if that's the correct license, you would have to check, like, if each of the songwriters were all registered with BMI, then that would cover all of the songs. But it's not just enough to have a license from BMI. There might be songwriters who are registered with a different PRO that they would still have
So the judge's preliminary injunction said the Trump campaign couldn't continue to use the song without a proper license.
Correct.
But he is allowing the campaign to keep videos that already exist that include Hold On, I'm Coming. Do you know what the basis of that is?
But even if a song is used in the background of a video, you would still have to obtain a synchronization use. My understanding would be that at this point, they would probably go back into discovery and see what licenses they obtained and if he obtained all the proper licenses.
I was confused because Trump's attorney said that we are gratified that the court recognized the First Amendment issues at stake and didn't order a takedown of existing videos.
I don't think that's in line with the reasoning, but the court, I think that they would definitely want to go in and see what licenses were obtained and see if the videos that they're using with the song were properly licensed. When you use a song in a video, it's called a synchronization license, and you need to obtain a license for both the master recording, so whatever master version they use, and also on the music publishing side from the songwriters of the music.
I mean, do most campaigns go through all these hoops?
They should. There definitely should be someone in a campaign who is looking into all of the clearances required, whether it's just at a political rally or they're going to be using it in commercials.
There are so many artists, I counted more than 20, who've complained about Trump using their songs in his presidential campaigns. Some complained publicly, others sent cease and desist letters. And Trump has often continued to play the songs even after the objections were raised. Last month, they actually played a video of Celine Dion performing My Heart Will Go On at a Trump campaign rally in Bozeman, Montana. A post on Dion's Instagram page said the usage was unauthorized. It added, and really, that song?
That is definitely an infringing use, not only from the use of the music, but also the false endorsements, any potential trademarks that were used, and whoever the owner of the video footage is as well.
Isaac Hayes III called the preliminary injunction the first step in our copyright infringement case against Donald Trump and Donald Trump for president. They're seeking actual and punitive damages for each infringement, and they say Trump infringed the copyright 133 times.
So the nature of how our copyright works is once you have protection under the copyright, you registered it with the Copyright Office, then you are entitled for statutory damages and potentially additional damages, punitive damages like they're requesting, if they have sent these cease and desist letters and can prove that there has been economic harm due to the continued use of the song.
One of the things that Trump's lawyer said is that they weren't harmed by this. They weren't economically harmed by this. What kind of economic harm can you prove?
It could be that they lost other, for example, like imagine if this was a car commercial and the Isaac Hayes estate decided, okay, we have already had a deal with BMW, but then Volvo used it, So if they have existing licenses that this would put them in breach of, that's one issue, right? That they can show they've lost money due to this infringing use that was unauthorized. They can also show that they potentially lost other uses because of this false endorsement from the use of their music. And they can also use the fact that they were in active negotiations, potentially with other publishers or whoever they are, that the use of their music lost value because of a campaign that used their music unauthorized.
That sounds a little more difficult than I thought. It's not just give me economic damages because you used this song 133 times without my permission.
No, the statutory damages are set by the U.S. copyright law for each infringing use, right? But economic damages or for punitive damages are, more nuanced, and they would have to prove that they potentially lost other licensing opportunities and it damaged their name, image, or likeness.
There's a little bit of a twist here because Sam Moore of Sam and Dave was against the filing of this lawsuit.
So Sam Moore had performed the song at an inauguration concert for Trump, right? So what's interesting in the U.S. is that, Britney Spears can perform a song, but it's written by 4 different songwriters. But it's her who's on the master recording, who's a performer on it. So they would still need to get permission from the artist. So in this case where Sam is saying like, hey, I gave permission, or potentially saying I'm okay with the use, if one person out of 4 songwriters denies the use, then you cannot use the song either way.
Actually, Trump's lawyers filed a sworn statement from Sam Moore with the court where he said he was opposed to the actions taken by the Hayes estate. That carries no weight, I take it.
No, not really. There's a nuance to the U.S. Copyright Act where a songwriter of a composition can license the use of a song for non-exclusive use just solely in the U.S. But that does not really extend to public performance uses because those are controlled by the public performance organization, and the campaign would still need to obtain a license. And if a songwriter from one of the songs has already asked the PRO to exclude their music, then they couldn't grant the license.
How much does a public license usually cost? Because the Hayes estate said it would allow Trump to pay a, quote, very discounted $3 million licensing fee. I mean, are they that high?
No, I don't. The public performance license depends on what the nature of the use will be, whether it's just like for the life of the political campaign, which lasts up until a candidate is sworn into office. I'm not exactly sure what the price is for each TRO, but I don't believe it's in the millions.
This is much more complicated than it seems at first blush.
Correct. It's a very complicated licensing structure also due to the fact, like, these are very popular songs, right? And you're able to find the songwriters. But there are some songs where you don't know who owns what, who the administrator is. So it's a very difficult process. But, you know, there should be someone on a campaign who has, you know, the experience, and it's in their wheelhouse to obtain the licenses so that each political campaign is properly licensed.
It's going to be fascinating to see just how this case plays out and whether they're able to prove economic harm. Thanks so much, Heidi. That's Heidi Vaccarano, a partner at Fox Rothschild. And in case you're wondering, Trump is apparently back to using the Village People's YMCA to close out his rallies. That group reportedly sent a cease and desist letter to Trump in 2023 over his use of their song Macho Man. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.